Okay, here is a very serious situation here. Okay, I'm gonna increase this. Get into some parental controls here. Um, right here, 18 U.S. Code Section 794, gathering or delivering defense information to aid foreign government. Under Chapter 37, espionage and censorship. Part 1, crimes. Title 18, crimes and criminal procedure. Okay, this is what it says down here. The provisions of subsections B, C, and E through P of Section 413 of the Comprehensive Drug Abuse Prevention and Control Act of 1970, 21 U.S.C. 853B, C, and E through P shall apply to property subject to forfeiture under this subsection, any seizure or disposition of such property, and any administrative or judicial proceeding in relation to such property, if not inconsistent with this subsection. The thing about that is that they're talking about the Comprehensive Drug Abuse Prevention and Control Act of 1970, which would also address matters concerning illicit access to controlled substances that are scheduled as narcotics or that are scheduled as other dangerous drugs. And the whole point was the concern I had when I submitted my original petition for in-bank review was that refusal to address appropriate policy concerning acquisition, consumption, storage, and distribution of controlled substances could potentially be an enticement or extortion into agreeing to commit other crimes. And that in consideration of the fact that there were other matters going on, including in addition to this situation being that people were listed as assets for the time that they were in these shelters, being compelled to acquire illegally access to controlled substances, that they were being classified as assets of companies that would be suppliers of the component materials for the manufacture of chemical weapons and potentially even biological or nuclear weapons. That the types of offenses that were occurring needed to additionally be considered in the context of who was refusing to take responsibility for the fiduciary impact of the policy breaches. And then you have to look at who's on the board of directors, including an electrical engineer from Boeing and including somebody alleged to be law enforcement in the vicinity where these crimes were occurring. Just from that context, right there, especially when you have a situation where people are trying to compel you to engage in intentionally and knowingly illegal activity or misrepresentations of your identity, including an identity as either a veteran or a dependent of a veteran in order to access resources and or to engage with them as if they were a veteran in order to get you access to resources, then calls into question, well, why is nobody on any level of jurisdiction taking those charges seriously? Because now the question needs to be inverted and asked, is this conspiracy to promulgate this unverifiable slander campaign alleging that certain people are spies that are trying to infiltrate the government actually about trying to cover up for acts of drug trafficking as a method by which to commit other crimes that actually do constitute efforts to aid and abet the enemies of the United States? And so then the question becomes is, well, what technically constitutes espionage in order to define something as a form of spy, craft, or spying? And the question of that is of material concern because if it's allowed to be characterized as spying, then there is a presumption of an acceptance of classifying it under national security as being allowed to either be classified and or done in such a way as to effectuate an extrajudicial proceeding that denies rights to due process to those who are allegedly implicated. And that gets back to what was one of my original concerns, which was that elements of the Affordable Care Act were being disabused in conjunction with elements of the original NASA Act to allow for people who were political opposition to be mischaracterized as disabled for the purposes of being abused in the expropriation of their property and their intangible property through the misrepresentation of them as being disabled, including in manners that could be used for research and development, for things that could be classified under the space technology components of the NASA Act. And once that was established and allowed to occur, including in a possibility for normalization, i.e., the use of their expropriated human capital and or test regimes to which they had been subjected that may have been used for the development of space-based technologies like satellite technology or various forms of radio frequency modulation that would allow for the outlay process connected to different stages of telemedication using SatTel, for instance, would then be allowed to be identified as being the kinds of technologies that would be classified under space-based technologies, which would then put you into another realm of consideration around espionage. And then, under the espionage components of the original NASA Act, one can be called out for their loyalty by somebody doing so, making a direct remonstration to, I believe, the Attorney General. And so now you're talking about something that is a very specific and different process when it comes to allegations of espionage. The definition is loyalty to the United States, which brings into question the demonstration or the concern that allowed for the original allegation around disloyalty. Then we get into a legal definition of loyalty, and then we get into qualifications of who is allowed to represent themselves as a state actor that would then be able to qualify as somebody to cast an allegation on somebody's disloyalty to the country. Because it is disloyalty to the United States. It's not disloyalty to an individual within the United States. So who is qualified to cast or characterize or to present the allegations of espionage? So that gets into what is the definition of espionage and who is qualified to present the allegation for espionage. If it says here, right here in this bill, it says, and it says this other places, if two or more persons conspire to violate this section and one or more of such persons do any act to affect the object of the conspiracy, each of the parties to such conspiracy shall be subject to the punishment provided by the offense, which is the object of such conspiracy. You know what this means? You don't need two witnesses. So you can take a woman like me and you can isolate me from everybody else in the world, and if his ass is totally engaged in treason, if I don't repudiate it, then you could create a false justification for attempting to misrepresent that I am complicit with that conspiracy. How many other people are you doing that to? How many other people are literally and have literally been involved in highly illegal activity for a protracted period of time that has been covered up and are now extorting a new round of people into compliance with a different calibration? This has been my concern the whole time. This has been my concern that this is what they're doing. This is part of what I'm concerned is actually Operation Mamacita. That's what they're doing. I call it that. That's just a name I made up because the understanding is old boys or retirees or boys that did what they did to make sure somebody got their contract hooked up are going to get their own Mamacita, right?